Great, thank you. So I've been all set up. Right, so the other problem is obviously here I've now trying to use our corporate identity from the University of Sheffield, and I think the kind of colors don't really work very well, but we've been asked to use this PowerPoint whenever we can. So anyway, I'm very much looking forward to talking about different strands of my research, coming from a company law, corporate governance background initially. I've moved a bit more into the kind of legal aspects of corporate social responsibility, and that particularly in the context of supply chains that we've already heard quite a lot about this morning. And supply chains are an evolving field of legal regulation, and there's quite a lot of contentious debate. My particular question here is, and I'm bringing a few pieces of work together that I've worked on during the last 1.5 years, and try to bring them together, put my thinking where I am, and hopefully get a good debate afterwards with a few new ideas about the further development, is how can law, or what kind of public governance, I use governance instruments, but basically what kind of regulatory instruments are best used to steer the behavior of corporate, of multinational enterprise at the top of the chain towards promoting greater social responsibility, which resonates with the topics we've heard about before, that they're very powerful, they're at the top, they've got the bargaining power. But our perspective, my perspective, is always what can the law do and how can the law do this? So it links very well with what we have heard before. I'll put this briefly into a theoretical context of interdisciplinary literature on global value chains, more managerial, and the politics literature on public and private regulation, the interaction between public and private regulation. I've got some empirical data from a study this year that I've been part of for German Investor magazine called Fuchsbriefe, which some of you may have heard about. And I looked at supply chain policies, and I thought, since we are here in Germany on home ground, it's quite nice to bring those empirical data about German companies into the debate. Very briefly, because we've had this several times, the regulatory framework, but I'll more use that towards thinking about the way ahead. How can law play a role within this developing framework? And this is where I'm really looking forward to question also having the debate afterwards, having this field of experts in law, what your thoughts are about how law can better steer corporate behavior towards promoting greater social responsibility. So this is a very simple image, but I think the main message or the main question comes out quite well here. It's with the buyer at the top and the different tiers of the supply chain, raising all sorts of legal challenges, obviously, from a regulatory perspective, and touching liability, but also showing that power and the fact that the question focuses on the steering of the buyer behavior, so the top of the chain, towards what happens within the chain. So that is obviously then the theoretical framework of this paper, that, as we've heard, law suddenly has come into the debate, but chains, supply chains, value chains, however they are called, have been quite a topic in other disciplines for a long time, particularly in management studies. We've looked at the kind of global value chain theory, and they've theorized how economic upgrading, how value happens, how value is attached at every instance of the chain, with all the problems that we've obviously talked about. But one thing that was missing in this kind of literature when I came across it is that law hasn't really been part of those debates, which is a quite strange point, seeing that supply chain relations are contractual and they very much rely on law. So law is at the very heart of the chain and what happens within the chain, and also my paper here. But in those papers, or those kind of literature, law always played a very minor role, which I think is a significant problem. Interestingly, in those debates, social upgrading, in addition to economic upgrading, seems to come into the literature as well. So there is a recognition that CSR plays an increasingly important role within those chains. But a recent research manifesto that has been published, I think, a year ago, quite clearly put out the kind of missing element of law within those debates, and argued law should be put at the heart of the debate about global value chains rather than playing a minor role. At the same time, I think the kind of paper here also looks at the literature on the interaction between public and private governance. Because we've talked a lot about kind of voluntary instruments here, soft law, and they are in the private sphere, what companies voluntarily do, non-state market actor-driven initiatives, and we need to distinguish that from the kind of hard law. So we're in a proper hard law jurisdiction here, the kind of hard law, the public governance instruments that the state can do. And there's often a lot about talk, what law can do, but there's not enough kind of filling of that discussion. I think that's what I would like to contribute to. And interestingly, there are two perspectives, and then I stop with the interdisciplinary perspectives, but there are two perspectives in the kind of more political literature on the public and private governance interaction. And the one is that public and private governance are complementary, and they help each other work together towards an improvement of the situation. And some scholars argue for a displacement. So private governance can displace public governance. And that's quite interesting. I think with the focus here, recognizing that increasingly the home states of multinational jurisdictions such as the UK, United States, we've heard the Netherlands, Switzerland, there are debates in Germany at the moment with an expert report. All those countries obviously look towards regulating, and that's home state regulation. And I think that home state regulation adds that kind of to that question whether or not there's complementarity or whether there's displacement. I think if we look at the complementarity aspect, then the question is how can this home state regulation complement the private governance instruments. Very briefly, because I think that shows where we are and why I think there is a need, if we want to change things, why there's a need for public regulation, public regulatory instruments towards promoting the status quo in global supply chains. It's just to look at data. I mean, we've heard lots about the kind of violations of CSR. We know talk about the governance gap, regulatory gap. I've just one more example sort of transpired when I looked at empirical data this summer. It's a small-scale study. As part of a member of 4 jury members for the magazine Fuchsbriefe, we looked at how transparent the top 30 listed German companies, DAX 30, are about their compliance. So we looked at issues such as their employee code of conduct, their supplier code of conduct, what they reveal about their compliance management system, how transparent they are about their risk analysis, and a business journalist looked at how they deal with problematic cases related to their company. And I was part of my jobs was to be in charge of assessing the supplier related information, the supply chain relation, particularly the supplier code of conduct, which is obviously at the heart of the supply chain. And interestingly, the results were rather mixed, rather quite mediocre. We looked at I looked at the topics that were covered. I looked at the stringency or the wording, is it firm or vague? I looked at the international embeddedness in conventions such as UN Global Compact, the reference to it, International Declaration of Human Rights, OECD instruments. I looked at also the kind of sub-supply chain instruments, what is said about the sub-supply chain. I looked at the monitoring information and the sanctions. And the results were rather mediocre for the majority. Some were demonstrating best practice, so they were very transparent, which resonates what we've heard before. There are some companies that do use those instruments to reveal and try to work together with stakeholders. But interestingly, 6 out of 30 companies didn't publish their supplier code of conduct. So obviously that doesn't say there isn't one, because there is no need to publish one, but it's interesting. That was what you wouldn't expect from the top 30 companies. In terms of the quality of the codes or the stringency, in terms of how binding they are, where we found most problems were that they were quite vague about the monitoring, the sub-supply chain, and the sanctions, which links to the issue that we repeatedly have with private governance, that you can have a lot on paper, but what matters is actually if you walk your talk. So if you do things to make sure these promises are enforced. And I've put the names on here. We haven't had any legal injunctions so far with the magazine that was published, so I'm quite confident now that I can use those, because the press conference was end of August, and some companies were even represented there. I've heard one of them at least today already as a company that has also been involved to some extent here. But it's interesting that you get them across the board. And it just shows again that perhaps there is a lot of saying, but not always enough that is done. Some certainly do, some don't. and how can we level the playing field, and that is obviously through the power of legal regulation, and that's the debate that we need to have then, seeing the deficiencies that we have already debated today. So we have a trend towards home state regulation. Why do we have this? Because there's an absence of international binding rules, because there are problems in host states, there's increased civil society pressure in home states, so the seats of the multinational enterprises. And it's interesting towards what this is developing, because it's quite incoherent to some extent. And I think this is part of the problem as well, because we have heard that comment about the proliferation, but at the same time, the kind of incoherence of those legislative frameworks. What we see is, for instance, if we look at the UK Modern Slavery Act, doing some legal analysis at least in a hard law jurisdiction, is that we've heard this transparency supply chains clause that has been implemented in the Modern Slavery Act 2015, which basically requires companies to issue a statement of the steps the organization has taken during the financial year to ensure that slavery and human trafficking is not taking place in any of its supply chains, or that the organization has taken no such steps. That's the basic requirement. Then there's a list of issues a company may include information about, including due diligence processes in its business and supply chain, but obviously the emphasis is on the may. So this is why when Charlotte referred to those different studies that have been conducted, there's a lot of critique about the status quo and the impact that this reporting regime had. And also interestingly, this reporting regime in some parts of the business community didn't meet the same resistance that I think Jill referred to about. Yeah, the kind of business resistance, because the may, and also because it's a level playing field, because California already had a regime that was similar, and it's quite light touch. So in terms of thinking about the interaction between public and private, it does make you wonder as a lawyer to what extent this steers behavior, to what extent this does change behavior. Obviously, I wouldn't go as far as saying it doesn't, because there are always learning experiences, and there's definitely more reporting. But the question is about the quality and the comparability and the impact it has on the kind of private governance behavior of companies on the basis of this public governance regulation that we have. So what do we have? We've got very diverse pieces of regulation, which traditionally are very much based on disclosure, which we've heard. Disclosure has been the instrument of choice for what someone has called last year chain law. So I don't know whether we will get chain law, but I found it quite interesting that someone coined that phrase chain law. So perhaps that chain law that is very domestic, very national, traditionally it's been very much based on disclosure. And I think you can see the existing instruments as part of a continuum, from the very soft end, which I think the UK example refers to the more stringent end, which is then imposing duties. And I think this is what Charlotte also said, that we're sort of moving towards a more binding in some jurisdictions. So the UK is traditionally, for various reasons, always focusing more on the soft. And I've seen the Australian consultation on modern slavery, which I think has two private governance, and the public governance would be the UK transparency clause. So that would follow that kind of lead. But then the French law, which obviously has been watered down by the Constitutional Court a bit, but the French law imposes a due diligence duty. We've got the Netherlands with child labor, and we've got in corruption and bribery the UK Bribery Act, which has extraterritorial criminal corporate liability. A contentious issue, because not all jurisdictions obviously have corporate criminal liability, and it hasn't really led to so many convictions or fines, but that wasn't the purpose. The purpose was there to provide an incentive to companies, because there's a defense of adequate procedures, and due diligence mechanisms constitute adequate procedures. So companies that do conduct proper due diligence policies within their supply chain and with their direct business partners, they are subject to this defense, so they can defend themselves. And that seems to have steered behavior, which I've looked at last year in a kind of small-scale empirical study, where with someone from political science, who's obviously far more advanced than I am when it comes to empirical work. We looked at policies, and we looked at supplier codes of conduct. We looked at publicly available terms and conditions of purchase. We looked at the reporting, at what companies say and what they have policies about the two issues of modern slavery and bribery. And I've been told by the social scientists very, very clearly that there's obviously not a causal link that I can prove, because I would need to look at what happened before those laws were enacted and what we have now. But it's interesting to see at least some kind of evidence as to how companies operate within those two regimes. And what we found out is that there's a hierarchy of issues. The bribery act seems to really have steered change quite tremendously, because there are annexes to the terms and conditions. There's very stringent wording. The reporting talks about zero tolerance. They even mention they have whole chapters on it, on bribery, the UK companies. So there's a lot of talk about anti-bribery, and the supplier codes are usually quite strong and very binding and very firm when it comes to prohibiting bribery. Modern slavery, not to the same extent. It was much more vague, aspirational. We strive towards eradicating modern slavery. The reporting was, we do a bit here, a bit there, but it wasn't to the same extent that bribery is. And I found that quite interesting. Obviously, it's a small-scale study, and it might as well change in 3 years' time because of the learning process that the Modern Slavery Act with this reflexive regulation has achieved. But I'm rather skeptical. I think from a legal perspective, if we go back to our legal analysis, then obviously the kind of more stringent hard law approach naturally transpires and relates to more stringent private governance reaction. And I think that that was a very interesting point to take home in this kind of evolving home state developments, that we need to question ourselves very clearly with what we legislate. Is it legislation that is intended to really steer the behavior? Then clearly it needs to have some duties, and it needs to be binding, it needs to be firm. Or is it regulation that just, ironically or sarcastically you could say, makes us all feel good, because it offers something to everyone. It offers to the politicians the opportunity to show they've done something. It offers the opportunity to business to say, well, there is regulation. And at the same time, for the society, for civil society as well, to see that they've achieved something. And I think this is something really carefully to think about, the kind of legislation. So I think the danger is what we see is CSR is often seen very critical in sections of the debate due to the fact that CSR is turning into PR-style, soft, vague instrument. And now due diligence is coming into the fore. And due diligence is like the new buzzword and the hot topic about how we can achieve better responsibility in supply chains. And I think as in legislation, we have to be very careful with how we deal with due diligence. Because if we carry on doing with what the Modern Slavery Act in the UK has done, it may include information without specifying to any extent what this means. Policies, numbers, auditing, whatever, then companies can basically do what they want, and there's not much to be gained from the reporting at all. I think this is a kind of word of warning that new laws, new domestic legislation has to be very cautious about the way how it deals with due diligence and how it refers to due diligence. So that means, how do we move on from here? And I think the focus now needs to be a mutual learning experience between law and empirical research and what works. I think there needs to be a focus on seeing how the laws to what they lead. And I think the UK Modern Slavery Act, in my sense, is a bit of a warning example. So the fact that Australia goes for the same soft standard is a bit of a concern. We now need to see what the French law after the decision of the Constitutional Court will or will not achieve, because that's obviously a question that remains to be seen. I feel that the Bribery Act, there is some evidence, although not a causal proof, but I think there's some evidence that shows that it has led to behavioral change. And if we want to have certain issues to lead to behavioral change, such as forced labor, then I think we need to think carefully about those things. And the other factors, what is gained from a comprehensive approach, a hybrid approach. that was mentioned before through the various papers, that the different stakeholders need to work together. And I think that kind of interaction between public and private in this field is very important, because at the end of the day, we've got significant legal challenges to deal with. We've got the host states, the countries where those violations occur, that are primarily legally responsible territorially to deal with those things. We've got the kind of the chains that make it contractually very difficult because of privity of contract, to ensure that what happens between the buyer and their first-tier supplier goes through to the second-tier, third-tier, fourth-tier. So we have got all those legal challenges which lead to what's called that regulatory gap. And I think this is why we can't just assume or expect one instrument to achieve the change. So we have to be rather skeptical, but that doesn't mean that there is no place for law. And this is kind of my argument. But then we need to think how to define that law and how to give power to the different parties in it. I think as company law and corporate governance, and Axel mentioned that public situation, yes, I think at the very least, looking at from a UK perspective, it should be more open. It shouldn't firmly say a company ultimately needs to favor the members, the shareholders, which the UK has decided to legislate, because that obviously makes a firm statement towards one of the different stakeholders. So I think that's a problematic situation in here. I think legally also we need to focus on enforcement. We've got different stakeholders within the four, and Peter and I had obviously conversation about consumers, and I think if we talk about investors and consumers, we need to think about how we can empower them. And my argument here is if companies do decide on business case reasons to publish statements and to release codes of conduct, then we need to think about instruments or ways of ensuring that they need to comply with this if they voluntarily decide to release these kinds of information. So the enforcement factor, I think, is very, very important. Also, talking about the theory behind the instruments, I know people are always very skeptical when, as a civil lawyer, advocate a return to kind of hard law or command and control regulatory style of regulation. But I think that disclosure as a learning exercise has its strength, but at the same time it has its severe weaknesses, as we've seen. And we're sort of coming to a point where we feel the exhaustion of disclosures. Not to say disclosure doesn't have any power, it needs to be well designed, and it needs to make things comparable. But there's a bit of a danger, I feel, at the moment, that there's lots of disclosure laws because it doesn't harm anyone, really. And I think this is where we have to be careful about how disclosure laws are being drafted. This is why I think we need to focus on stringency, if we want to legislate, if we want to change. That's obviously a decision that legislators have got to make. But I think the stringency argument is very important. And this is what the kind of bribery, modern slavery comparison has shown. And I think which also comes slightly clear when you look at the empirical evidence of the top 30 DAX companies, that there's still very much an inconsistent way of approaching the supply chain, approaching the reporting of the supply chain, the information that is being released, and the extent to which the companies are actually binding and ensuring, trying to ensure compliance with the provisions they impose on their suppliers. I also think, having done a PhD on private law and CSR, that private law on its own isn't doing the trick. Private law is important, but private law has its clear limitations, obviously by the very nature of private law, being between the individuals, company law's role, and I think we need to recognize that kind of public element in here as well if we want to drive the change. And the French law, that's what the conversation with French lawyers have shown, is going more the kind of public duty imposition. So that's also something to consider. So the kind of focus is, or the end point is, we need to consider what works. I think this is very, very important. I know there's still a bit of time left, but the focus is on my kind of closing. We need to think what works. And that leads then to the kind of debate how law can contribute to the public-private governance interaction, which I think is very, very important, and also to the kind of evolving global value chain theory that law has got a role to play there. And I think I'm going to leave it there, although still a few minutes left, because hopefully there are a few questions. Because I think the kind of public-private debate is one where I'm quite keen to hear the comments on. what you feel about having heard the kind of comments about disclosure and what public instruments can do to achieve the change. Because I think this is where we now need to look at. Thank you.